Would you stand, please? As I have already stated, there will be life sentences in each of your cases. Taking as the appropriate start point for the minimum term 17 years, then balancing the very serious and significant aggravating factors identified and making some allowance for maturity, leads to an initial uplift to 22 years and then a reduction down to 19 years, then allowing credit for plea, a minimum term of 15 years, 10 months. That may also be expressed as 15 years, 300 days. The days on remand number 190, and those days will therefore be deducted from the minimum term. In each of your cases, the sentence will be one of detention during His Majesty's pleasure, with a minimum term of 15 years, 110 days. What that means is that before you will first be considered for parole, there will be a period of 15 years and 110 days. If the information which I've been provided with as the days on remand proves to be inaccurate, then the prosecution or defence must notify the court so the case can be relisted to correct the calculation as soon as possible, and in any event within 56 days. When it comes to that minimum term that you will serve, I make plain that I am not ordering that you will be released at the end of it. Whether you will be released or not at that stage will be a matter for the parole board to consider. Only when the minimum term has been served can the parole board decide whether it is safe to release you or not. If the board does release you, you remain on licence and liable to recall for the rest of your lives. On counts 2 and 3, there will be concurrent determinate sentences. As there are previous convictions for similar offences, in my view there must be a minimum sentence. Here, the appropriate sentences are concurrent sentences on both those counts of 12 months detention. I ordered the forfeiture and destruction of the machete that was recovered. And if the statutory surcharge applies, then the appropriate order can be drawn up. You may go down.